Ready when you are.
Hello everyone, welcome to this webinar on mediation. My name is Camilla Palmer and I am a mediator. I do private mediations and judicial mediations, but I have for 20 years been an employment litigator, and that includes acting and advising doctors about their particular situation. So I do understand how the litigation process costs time, money and stress. This morning I looked up what is the problem with conflict in the medical field, and quite interesting to see what it said, which was conflict in the health arena is a growing concern and is well recognized for doctors in training. Its most extreme expression, workplace violence, is on the increase. There is evidence that many conflicts remain unsatisfactorily resolved or unresolved and result in ongoing issues for staff morale. So I'm a great advocate of mediation. Why? Conflict is obviously common in everyday life. It's common in the medical field. It's common in employment. There can be positive conflict, i.e. constructive discussion about different views, but most of it is often really fairly negative. And just to give you one example of the cost of workplace conflict, I'm not necessarily talking about that today, but it costs UK employers £28.5 billion every year, according to the Conciliation ACAS report. And that reports that failure to deal with conflict early impacts on productivity and health, which is well known. It causes stress, anxiety, and depression. And mediation can mitigate the consequences of conflict, enabling parties to move forward. You will all at some time have experienced conflict at work. And I think that in many cases, people hide their head in the sand and don't do anything. And what I would say is that it's really important to grab the nettle, as it were, and deal with conflict early. And again, mediation is relevant at the beginning of the dispute or at any stage during a dispute, even if it is litigation. So what is mediation? I think that it is not very well known. My experience is a lot of people really do not understand what mediation is. The aim of mediation is to resolve conflict and disputes constructively, saving time, money, and distress. And it is an impartial mediator who is chosen and agreed by the parties, help the parties find a solution. And it may appear that you have conflict where there is no solution. But what I have found as doing a lot of mediating is that you start a mediation, you may think, oh, well, this is never going to get resolved, or just before lunchtime, you think it's never going to get resolved. But by the end of the day, the solution has been found. And it just saves, if there is an agreement over how to resolve a conflict, it just saves so much time. It's also an informal and flexible process to suit the parties. And I think that is really important because there's no one size fits all in a mediation. The mediator has to look at what the issues are, look at the impact of any issues on the individual, and help the parties find a solution. You can have a mediation where the parties don't actually ever meet, but that rather depends on the type of mediation, because if the aim is to mend a working relationship of some sort, then often you do need to have a meeting between the parties so that they can understand better each other's position. So it is a very flexible process and informal. And the other, I think, important point is that the parties very much have control over the process. If you go through a formal process, like a grievance at work, there isn't very much control because the one party determines what's going to happen. With mediation, it is the parties really do have control. And this is really borne out by the fact that all parties must agree to mediation. So if one agrees and one does not, then there can be no mediation. It is, at the moment anyway, it may change, a voluntary process. So a party can withdraw, having just agreed, a party can withdraw the day before, or a party can withdraw on the day of mediation. So, for example, if one party doesn't like what is happening or what the mediator says, for example, then they can just say, I'm not continuing with this process. I have to say that I've done a lot of judicial mediations, and it's never happened that a party has just withdrawn. But the mediator needs to know, of course, and they will know, that they have no control, really. It is the parties who have control. It's also important that mediation is confidential, and that can be a real advantage. It's confidential in two ways. First, that nothing is said in the mediation can be repeated in any sort of litigation or outside the mediation. And it's confidential in that a party can give the mediator information and say, I don't want this passed on to the other party or the other parties. And it's only what the party says can be passed on that will be passed on to the other party. So when to mediate? My view is it's never too early and never too late, pretty well. I'm just going to... And so it could be at the beginning of a dispute, or could be in the middle of litigation. And as I said, however far apart the parties are, often agreement is reached. So mediation resolves conflict, hopefully. And moving on to types of mediation. There are a number of different types of mediation. There's a workplace mediation, for example, which is disputes between colleagues. The aim usually being to improve working relationships. And that is different from what is called often a commercial mediation, which is where money is involved or where the relationship is over. And it is just about trying to work out what will happen to the relationship between the parties, what agreement can be reached there. And then there is judicial mediation. If the dispute goes to an employment tribunal, for example, you can agree to free judicial mediation by a judicial mediator who's also a judge. There is also other ways of engaging with judicial mediation through the small claims court if the value is less than 10,000, but I'm not going to get into that detail. So a mediation could be between two doctors or a doctor and a medical student. It could be an allegation of harassment or discrimination. It could be a whistleblowing issue. I was involved in some cases of whistleblowing which are notoriously hard to resolve, and I think early mediation there can be very, very helpful. So, pros and cons. As I said, focus is on solution. And it's important that it is about avoiding aggression and the blame game. Often when there is conflict, each party is blaming each other and it starts to be quite aggressive. And that is not what happens during a mediation, which is one of the main advantages. The aim of mediation also is to diffuse anger and blame and avoid stress, time and costs, and give the parties control over the solution. It can help mend relationships, even relationships which appear to be broken. I have certainly seen that happen. And mediation is now, mainly since COVID actually, quick and easy to arrange, particularly online. Almost all the judicial mediations are done online, and a lot of the private ones are done online. You don't need to travel anywhere. You don't need to find rooms to put each party into a room and the mediator into another, because if you do it with Teams or Zoom or whatever online platform, there are rooms that are set up for the parties to go into, and the parties can meet, as you will know, on Zoom or Teams, or they can be in their separate rooms with the mediator going backwards and forwards between them. I don't know how many of you have been involved in litigation, but those who have will know that if the dispute ends in threats of litigation, and litigation that can take a long time and is uncertain, it's costly, it's stressful. Now, you may say differently, but I can't think of any real disadvantage in going for mediation. I should have said at the beginning actually that there's going to be a Q&A session at the end after half an hour, and please put your questions in the chat, and I will answer them. So when to mediate? It's never too early and never too late, as I've said. The only exception is if conflict can be resolved informally between the parties, so mediation is not necessary. Always try and have a conversation where there is conflict or a dispute and see if it can be resolved, and if it can't, then think mediation. I always say think mediation first. Examples, there are so many examples, but basically the principle of mediation are very much the same. It could be disagreement about money or a contract. It could be allegations of harassment, discrimination, bad behavior. It could be a breakdown in the working relationship, or it could be about the exit terms. If, for example, a GP is leaving a practice, and there are many examples. So again, do ask questions if you have any particular situation, so without giving details of names, about whether it might be a good time to mediate. So just going through now the process. First of all, before the day of mediation, first of all, you need to choose the mediator. You need best to have a fairly experienced mediator, but certainly in the employment world, some employers do not want to have a mediator who has mainly acted for employees. I don't think this makes any difference at all. I think that the mediator will be impartial. They won't be swayed in favor of one party or the other because they're trained not to be, and usually that is the case. And you want someone who is going to be a good mediator. Documents. Now, sometimes in mediations, I see a large bundle of documents. And my view is the fewer the documents, the better. The aim of the documents really is just so the mediator can understand what the issues are, but not decide, and the mediator is not going to be advising or deciding who is right and who is wrong. It's often the case that both parties know they're right, and that is not going to be resolved usually during a mediation. The relevance really is to understand what the issues are and what the impact of the dispute is on the individuals and how to move forward. Then there are slightly different methods of mediation depending on whether there are two people who are trying to resolve a problem internally, and there's no question that either one or other will leave. But if in that case, it's almost always the case that the mediator will speak to both parties separately before the mediation and understand exactly what the problems are that they have, how they have experienced them, what their view is, and what they want as an outcome of the mediation. And sometimes this is called a position statement. My view is it shouldn't be about I am right. It should always be a positive position statement, which is focusing on trying to resolve the dispute. Who attends a mediation? Sometimes both parties will have lawyers. Sometimes one party will have lawyers. I don't think it's necessary, and sometimes it's an advantage not to have lawyers attending a mediation. If there are lawyers attending mediation, as a mediator, I ask them to take off their adversarial hats and put on their mediation hats in the way that I do, as I'm an employment judge as well. I do when I'm judging judicial mediations, helping with judicial mediations as a mediator. But lawyers can sometimes be helpful. It depends. The decision maker must always be present at a mediation if there is a decision maker in relation to the dispute. Pre-mediation discussions with the parties. Sometimes this also helps because one party may be very nervous, not understanding what mediation is, and the mediator can explain and also reassure them that it's a very flexible and informal process. So I mentioned already the online process. Sometimes it is necessary to be in person, I think, particularly when there are two kind of warring individuals, as it were, because they need to work together in the future. So at some stage they need to meet. But it may not be at the beginning. It may be at a later stage. And if there is, for example, an allegation of harassment or discrimination, it may be that they don't want to meet at the mediation at all, and still an outcome can be reached to find a solution without them meeting. So again, that just shows how flexible the whole process is. The mediation day. Usually, or often, it starts with a plenary with the parties together. But as I said, if one party doesn't want to meet the other, that's not necessary. That is just to really explain the mediation process, if it has not already been explained before the mediation. It is not to argue about who is right and who is wrong. Again, that's not for the mediation. So what happens at the plenary may depend on the circumstances. It may depend on what the parties want. It may depend on what the mediator thinks would be most useful. What I like to see is both parties saying they are attending the mediation because they really want to find a solution. So you start the mediation on a very positive note. What happens next is that the parties will go into their own rooms, and there will be separate meetings with the mediator. So the mediator will decide who to go and see first, have a discussion about what's happened, what the problem is, how they're feeling, and what they want to get out of the mediation. It's a listening process for the mediator to understand what the parties want. Again, they repeat the confidentiality about providing information to the mediator so that it won't be passed on unless the individual wants it to be. And sometimes during the mediation, if the parties have not wanted to talk to each other one-to-one, it may be that after 2 or 3 hours, they are softening a bit, and the mediator might say, well, what about having a meeting between both of you, whether it's in person or online, with me present, so that there is no problem, or hopefully there is no problem of any sort of aggression or blame. So reaching agreement, sometimes hopefully agreement is reached at the end of the day. Sometimes there will be a written agreement. Usually there will be a written agreement, but sometimes there's not time. What I should mention is, in terms of the mediation day, you may be thinking, how long is it? When I did, as a litigator, commercial mediations, I was often there from 8:30 in the morning until 2 o'clock in the following morning, because everyone was spending 4 hours making a decision about what they wanted. And I think it's quite important to limit the time of a mediation, because, you know, by late in the evening, everyone is exhausted, and an agreement might be reached which is not going to be viable, unless it is really sealed by a written agreement. So I think that really 9:30 to 5:30 should be the norm. May go over an hour or so, but it certainly shouldn't go into the middle of the night. But if agreement's not reached on the day, it does quite often happen at a later stage. If there has been negotiation and offers of whatever sort, sometimes it's a good idea to leave the offer on the table for a period after the mediation. And sometimes, quite often actually, then resolution is reached. And if the parties meet at the end of the mediation in the same room, sometimes it does help future resolution. So I had a case the other day where the parties met and the respondent said, well, get in touch with me, you know, if you'd like to, about this. And the claimant said, yes, I may do. And 4 days later, I was told that they had reached agreement. So I suppose my motto is never give up, really. That I try and encourage the parties to stay the full day and continue negotiation following the mediation if they don't agree at the mediation. If there is, if the mediation is about an ongoing relationship, then it is often the case that the mediator may follow up with both individuals to find out how it is working. So that is worth thinking about. My motto for a legal charity I set up called Your Employment Settlement Service a little while ago was life's too short to litigate. I know that in your situations it may not be that you are litigating, but I think what is really important is at the beginning of any sort of possible conflict to avoid it escalating. And it's important to avoid threats of unlawful behavior. So a lawyer's letter often may say, for example, you have harassed and discriminated against my client. That is bound to escalate things, because allegations like that only encourage a response which makes allegations against the person who's had given the threats. I'm very much in favour of, if there is going to be, sorry, I went too far. If there are problems, is for the individual who has a problem to state the facts, and the facts will speak for themselves. And often, quite commonly, the conflict arises because there has been miscommunication. So one party may just simply not realise that what the assumptions they're making are not correct. So I would always say avoid making assumptions without knowledge of the facts. The focus needs to be on concerns and solutions. In the employment world, and maybe, I don't know if you deal with this, there's a grievance process, and that is, I think, it only ratchets things up because it contains all and every allegation one party is making, and then the other party is defending it, and then you have war on your hands, as it were, and litigation. Just to say about the future, I think mediation is likely to become compulsory in the civil courts. What the head of the civil courts, Geoffrey Voss, has said is that the whole system of civil justice will be focused on resolution. And by resolution, he means mediation first, not resolution by a court. And he is saying that continuous mediated interventions will be integrated into the whole digital justice system, making use of online or telephone to in-person mediations, early neutral evaluation or use of AI to suggest outcomes. So I do think the change is coming down the road. I have no doubt it is probably partly to do with money, or maybe wholly to do with money. I also think that mediation is a good thing, and it should be part of the civil justice system. My experience as a litigator for 20 years is that the parties, particularly the employee, but it could be either party, don't sail through litigation and get what they want, i.e. justice. It's an incredibly stressful, uncertain, costly system. People even sell their houses to get justice by litigation, and mediation can avoid all of that. So I'll be mediating. Hopefully, you will be more interested, and you may have experience of mediation, which I'd be interested in. But there's some, well, I suppose, top tips, which are probably very obvious. Avoid escalating a dispute with aggression and blame. It can be resolved without, well, unlikely to be resolved with aggression and blame, because it will lead to a defensive response. Always think dispute resolution, mediation first when there is conflict. I don't think there's anything to lose. There are some who say it can be a sign of weakness. It's a bit of an old-fashioned view, that. And when it becomes, if it becomes compulsory or encouraged more by the judiciary, I think the culture will change, and it will move more towards mediation. And never too early. Don't leave it too late when tensions are high and parties may be reluctant to try and mediate. So that was all I had to say. Well, I could say a lot more about mediation, but it would be interesting to have your questions and comments. You may have had bad experiences of mediation if you have used mediation. So very interested to hear from you. And I'm going to now hopefully understand how to look at your questions.
I can read them out for you if you prefer.
This is a new system for me. So sorry, I'm struggling a bit. Yes, if you could read them out, please. Read some out.
The first one I've got, what qualifications do you need to become a mediator?
Very interesting. It's not regulated in the way lawyers are. Usually you do a mediation course. There's the classic CEDA course, but there are a lot of different courses on mediation. And the commercial course on mediation, which is done by CEDA, CEDR, the Centre for Dispute Resolution, covers all those grounds, and then you have to observe a mediation before you can do a mediation. If you are as a judicial mediator, you need to go through the judicial mediation course. So it does, and that's all as a judge. So there is a movement to make it, to regulate it more.
Thank you. Do doctors have more problems because of egotistical issues? As a senior doctor, how can I help my profession with mediation?
I can't say whether doctors have more because of egotistical reasons. I think promoting mediation, if you have come across a dispute, is to suggest that it is resolved with mediation or some other dispute resolution process. I mean, if it's not a full mediation, it may be a facilitated discussion. And really, if you see people being aggressive and blaming, well, try and it involves you, try and diffuse that sort of blame and aggression and move people towards mediation. I don't know what sort of mediation services are available. I think the BMA offers mediation services. And a mediation could be just half a day. It doesn't need to be a whole day. But certainly stamping on that the egotists, I suppose, if you can, not stamping on them, but controlling them and suggesting mediation.
Just off the back of that, who can initiate the mediation and how?
Either party can initiate a mediation, and the way of doing that is to talk to the other party about whether they would agree to go into mediation. I mean, it depends a bit on the circumstances. Usually, if it's an employer and employee, it's the employer who usually suggests mediation, but it could easily be the employee. Really, either party can suggest mediation, and they can just simply say to the other party, why don't we try and resolve this through mediation? Rather than continuing the conflict in a rather negative way, or whatever is most tactful in the circumstances. But difficult to say unless I know the situation. But either party can do that, or someone outside can say to the parties, "Why don't you try mediating this?" Because there's no harm, and it may help the conflict, diffuse the conflict.
What happens if one party withdraws from mediation? Can anything be done about this?
Easy answer to that is no. You can try and persuade them to continue, or you can say that you're reluctant to stop the mediation, and can they take some time to think about it? But ultimately, if they want to withdraw, they will withdraw. I think avoiding that is avoid that. You need to know why they want. Maybe worth asking why they want to withdraw. If I was a mediator, I would ask why. But ultimately, they can just go.
What should you do if there's clearly a guilty party, for example, bullying or violence?
Well, I think either bullying or violence can be mediated. If the parties agree to mediation. I mean, an organization may think that if there has been violence, there needs to be action taken against the person who was violent. But that is really a separate issue, and that will be dependent on the circumstances. but if there has been violence, and I did hear the other day of apparently 2 doctors who had a fight in front of patients. This was apparently happened 40 years ago, so not identifiable. And if that happens, I think mediation can work. But then you probably need to monitor it on an ongoing basis, and the mediator may need to check in with the parties after the mediation. There are some cases which it may be hard to mediate if, for example, there's whistleblowing and it is seen that it's essential to investigate this because it has an impact on more than the parties themselves, and therefore there has to be an investigation. So it's to judge whether there has been whistleblowing and how to sort it out. So those are the sort of cases where you have to think about what is in the interests of not just the parties, but people outside the parties, whoever is affected.
That brings me on to the next question. What is said in mediation is confidential, but can parties involved in a mediation mention to outside people or parties that they are taking part in the process?
It's okay to say you're mediating, but not what's said in the mediation. But usually the parties would agree to confidentiality generally, but it's what happens in the mediation that is confidential and cannot be repeated. I suppose you wouldn't, certainly it would be very difficult if a party was using the fact that the other party had entered into mediation to say that they'd obviously done something wrong. I mean, I haven't actually known this to be a problem. Whoever's asked the question, was there a particular problem? Did this arise?
I guess it depends on different companies will do different costs, but who would pay for the mediation?
Well, that again depends on the parties. Sometimes if it's employment, the employer generally pays, but sometimes it's shared either equally, or if, say, it's a mediation between a sort of high-paid doctor and a student, then it may be that the higher-paid doctor pays more than the student. But I think the BMA does have a mediation service, but I can't give you the details of that. I don't know if anyone else can on the call. So it's all up for agreement, really. And there are some free mediation services. Not many, but there are some. And there are some judicial free services as well, like employment and also county court low value cases.
Could you please outline the informal versus a formal complaint investigation for medics at work? And what if a complaint is not upheld, but either does not agree to mediation?
So sorry, can you just repeat that? I'm just going to make a note. There are two parts to it.
Yep. Can you please outline the informal versus formal complaint investigation for medics at work? And what if a complaint is not upheld, but either does not agree to mediation?
Well, I think that if the complaint's not upheld and there isn't agreement to mediation, then there won't be mediation, because at the moment it's entirely voluntary. So there would be no recourse to mediation unless both parties agree. So, I mean, I think the other thing I'd say is that if there is a formal process, sometimes that makes mediation more difficult because a decision has already been made, which is why I would think first of mediating, unless there had to be a formal investigation. Think of mediating first to see if there is a solution which is agreed way forward, before the formal process. And certainly I know that in employment, the grievance process is rarely, the outcome is rarely satisfactory, because the person bringing the grievance thinks they're going to get what they want from the grievance, and often that does not happen, but it just entrenches the dispute.
Thank you. What if you don't have confidence in the managers who have put themselves forward to mediate in the first place?
Usually you would have someone from, sometimes there are internal mediators. Question is, are they really impartial? Because if the manager is not, if the manager, for example, comes from HR and HR is seen to be to support the management, then they're not really impartial mediators. And there should be a person who comes from the outside who has not had involvement with the two parties before, if there is to be a proper impartial mediator and mediation. Really important that the impartiality is really important. The mediator is absolutely not there to take one side or the other. And if they show that, if it seems that they are doing so, then the mediation is unlikely to succeed. But it is common, that scenario is common. I always think that companies, organizations should swap mediators. So a mediator from a different company is brought in, and then they if a mediator is needed, you swap around, bring someone in from outside, and then exactly the same happens with the other company, so that you don't have HR in the same company mediating with employees.
Do you have a view about mediation, about ethical disagreements, for example, the Charlie's Law amendment recently?
No, I don't, I'm afraid. Sorry. I mean, I think you can certainly mediate ethical problems if that's what is you're asking. I certainly think you can do that, because you can find a solution. You can find a solution often. It depends what the ethical problem is. Hard to say without knowing.
Can a doctor taking part in a mediation ask the mediator to provide him with an agenda for the meeting before it takes place?
There isn't really an agenda for mediation ever. That doesn't happen. But the answer is that the mediator can speak to the party and explain what happens at mediation and what is likely to happen. So what would be discussed, for example. But I don't think you can set an agenda, a normal agenda, 1 to 6, and then go through that agenda in a very prescribed way, because the mediator will decide how to manage with the consent of the parties and not start off with a prescribed agenda. So I think the answer is no. There wouldn't usually be an agenda, but there would be discussion about what will happen at the mediation, which may be the equivalent, but it's just not prescribed. The mediator would manage the mediation in a constructive manner, in a fair and constructive manner for both parties.
Do both parties hear the dispute that has been raised by the other party?
Yes. So the mediator discusses with each party what the dispute is, what it's about, and what they want the outcome to be. And what I would expect is maybe there need to be some sort of reframing to pass it on to the other party. In other words, instead of saying it was discrimination, saying I feel I was treated less favorably than X. And then the party A, for example, would then have to agree what the mediator said to the other party. So if party A really did not want the other party to know about a particular dispute, then the mediator would not pass it on to the other party. But obviously, the subject matter of the dispute would generally be known before the mediation, because the mediator would have spoken to both parties if it's about trying to resolve issues between two doctors, for example, rather than an exit package. So that the main dispute would be known by both parties. But if there was a sort of side issue and dispute, and one party did not want that to be passed to the other, then it wouldn't be passed to the other. The confidentiality that the mediator has is very, very clear. You don't repeat what one party has said if they don't want it repeated to the other.
Coming off that, there's actually a question that says, could the details of discussion at mediation be later disclosed at a formal grievance procedure by either party or the mediator? If yes, then would it not be better to keep records of the discussion?
No is the answer. It's confidential. It should not be used at a grievance hearing. So, because a grievance hearing as well, I mean, if it's an employment area, would then go before the employment tribunal, and that would not be allowed. I mean, because a mediation is confidential. That is the whole point of mediation. And if it can be used in the litigation process, and it could be if it was a grievance, then it is confidential, and it's pretty clear that. And a tribunal, if it was a tribunal, I think would be very where it wouldn't. I don't think I've never come across it actually. If it was a private mediation, or if it was a judicial mediation, it certainly would not be allowed. But if it was a private mediation, I'm sure that the tribunal would say that is confidential, and that's not something which would be admissible in the tribunal.
Has mediation been tried as an alternative to GMC agreed outcomes? And if not, then why not?
I don't know the answer to that. I don't know the answer to that. I don't work in the health world, but I think that it should be. It is often the case that mediation is not considered, and my view is it always should be considered, because it is generally a much better outcome. So I suppose if there was a serious ethical or medical or whistleblowing issue that had to be decided formally to protect others, then that may be different. But if it is a dispute between two individuals, then I can't see why mediation wouldn't work. But I mean, I think I'd need to know more about what sort of matters the GMC you're talking about, the GMC are deciding, before I could give an answer to that in more detail.
Just going back to the agenda, is it reasonable to ask for an agenda if HR suggests meeting the colleague after a shift and you don't know what the meeting is about?
That's not a mediation necessarily, though, is it? If you're about to go to meet with HR for a meeting, you may ask what the meeting is about and what's going to be discussed, because that's a formal meeting, which is not necessarily a confidential meeting. So I'm talking about the formal mediation process, where you wouldn't have an agenda. I can see that if it was an informal meeting, which was sort of on the record, then you may well need to know, you would want to know what was going to be discussed and have an agenda. I think it's different, though.
How does mediation overlap and differ from a restorative justice approach?
That's a difficult one. I mean, the mediation is mainly resolving disputes between two individuals, and anything can be discussed at a mediation, and any solution can be agreed. So you're not confined in any way. So if one individual feels they want restorative justice in certain aspects and sets out what they want, the other party can agree to that or can refuse it. So, for example, it's quite often the case that an employee wants the employer to change their policies or train others on discrimination. And if that is an ask, then the employer will consider it and may agree. So it's a good question, because one of the big advantages of mediation is you can discuss anything and anything can be agreed. Pretty well anything can be agreed. The classic is an apology as well, which in the vast majority of employers, for example, will not provide. But very occasionally they do. And for example, in one case I had the employer paid money to a charity, Black Lives Matter, I think it was. So it depends what you see as the individual sees as restorative justice, but mediation can heal.
What about in a situation where one party is looking for a positive solution and the other party is lying and has malicious intentions?
Well, a mediator can't stop that happening, but I think can probe the party who is apparently lying. But the mediator doesn't know who is lying necessarily unless it becomes obvious. And my experience of mediations is this happens very, very rarely, if at all. But it's almost always the case that both parties want to go into it to resolve. I'm not saying it doesn't happen, but it is up to the other party to say, I don't trust this person and I don't want to continue. And it may be the mediator says, well, can I pass on to the other party what you're saying about lying and etc. And find out what the other party says, because the mediator doesn't know all that has happened. Obviously, they're coming in fresh, or should be anyway, which is another reason why they shouldn't be really, well, from HR, because they will have too much of a background. So I think that can be put to the mediator can say that, but maybe not quite in the way you expressed it, of lying, but simply to reframe into the claimant, party A, is saying that this didn't happen and that this is not true, and see what they say. It may
Are there
be
any
that the mediator just brings the mediation to an end if there is that level of distrust.
Are there any circumstances where confidentiality cannot be maintained in the mediation process?
That's a very good question. I'm not sure whether, I have to say, I'm not sure whether if it turns out that there's a criminal offence committed, whether there is any obligation on the mediator to report that. I would have to take advice if it happened. But it would be that sort of situation where, for example, a child was at risk, or it appeared there was some criminality or risk to an individual, that I think that may be exempt the confidentiality. But to be honest, I don't know. If it happened to me, I would seek advice.
Can the trust insist that one mediates with an individual who is directly involved in formal litigation process?
Well, the trust can't insist on mediation. It has to be agreed by both parties. But certainly mediation, if both parties agree, can mediate during litigation, really up to the end of when the judgment is, and then even after then, up to the end of any remedy outcome. So as long as there is still a dispute to be mediated, mediation can happen. And I mean, as probably you know, there's mediation often, settlement often happens at the door of the court, but sometimes, quite not infrequently, parties ask for time to consider settlement mediation during litigation. So, which is why I say it's almost never too early and never too late to mediate.
This is a three-part question. When you say experienced mediator, what do you mean? Could this be an accredited mediator who isn't a lawyer? And what do you recommend for doctor-to-doctor mediation as a best fit mediator?
Well, you certainly don't need a lawyer. It depends a bit on the dispute, what experience you'd want the mediator to have. If it was, for example, about a complicated, or even not complicated, a contract between doctors, GPs, whoever, then I think probably it might be advisable to find a mediator who had some experience of what is the norm in that sort of contract. But having said that, mediators will mediate disputes about which they don't know very much, because they're not there to advise. That's very important. They're not there to advise. It's possible that they can do a bit of reality checking, but as they're not advising, then they're not expected necessarily to have knowledge about the particular area. I mean, I think as it happens, like, for example, personal injury and medical negligence mediations, if there are any, because there are many round tables, that it might be sensible to have a lawyer who had knowledge of what the court is likely to do if it might go to the court.
Thank you. We have reached 2 o'clock. Are you happy to carry on taking questions? We're not halfway through yet. There are still quite a few.
I have got to go when my bell rings, which could be after 2 o'clock, which is just after 2 o'clock. So I'm happy to go on until my bell rings, and then very happy if you want to contact me. I think my email address is somewhere. I'm now at Old Square Chambers. So
Okay, I do have
ask me a few
of
more, and when I hear the bell, I'll have to say I have to go.
Okay, no problem. And I do have a copy of all the questions as well, if you'd like to look at them after.
Oh, okay, yes.
How shall we decide on an outcome if this is an early reconciliation prior to employment tribunal?
If I'm understand you right, you're in ACAS early conciliation. There is a view, which is wrong in my view, that you can't mediate when you're in early conciliation. That's not correct. ACAS's role is very different, and even when they're trying to help the parties find a solution, it's not the same process as a mediation. They do offer, I think, some full-blown mediation, but you can always still mediate early. I think if it's a claim that's going to the tribunal, I would suggest that you ask the tribunal early if you can engage with judicial mediation. You may well find that the tribunal will agree if both parties agree, because they do offer that. I think they offer it at a different stage in different tribunals. They certainly offered it at the first preliminary hearing in the London Central Tribunal. And I think there's this ongoing discussion about offering it earlier when the response goes into the tribunal. So if you're on early conciliation, you can still mediate privately or wait for judicial mediation.
This is a personal situation. I'm part of a group grievance at work, a situation with management versus a group of doctors. Can a grievance be turned into a mediation?
Yes, if the parties agree. And it's a misconception that you have to continue. Lots of HR people say to me, we've got to finish the grievance. And I say, why? What I want to do is try and resolve it. And if the parties agree, then yes, that can happen. Absolutely no reason why not.
My experience of mediation is that the effects are short-lived and not sustained. The conflict is only really resolved once one of the parties has left the organisation. How can we, I suppose, make it a better work environment?
Well, I think that's a case where it would be a good idea for the mediator to be in touch with the parties after the mediation to ensure that whatever mediation agreement was reached between the two parties, that was holding up. Also, it would be worth trying to get the employer to maybe have another mediation, agree to another mediation. I think it is very difficult. If there's a really bad relationship, even if it's sorted out at a mediation, it doesn't always work. Absolutely, it doesn't always work. Those are probably the hardest ones to resolve on a long-term basis. But I have had mediations, or rather, I have intervened to try and find a resolution. And the first thing I did was to suggest to the employee that they actually put the grievance on hold and didn't pursue it, and had a discussion with the employer about, in fact, it was finding another job during maternity leave. And she did that, and she had a discussion, and she was offered another job, and she wrote to me 3 years later saying thank you. So I think that if the conflict hasn't ratcheted up to an extent that it's very hard for either or one party to kind of go past it, get over it, then it's more difficult, which is, again, the reason for early resolution and trying to sort things out before they get entrenched.
I have not had any training in mediation, but have to mediate disputes in my department when interpersonal relationships have broken down as a result of conflict. Both parties often want vindication, which is not the point. Any tips on how you can move the parties past that?
Well, depends how bad it is, I suppose. I think I would be tempted to have a formal workplace mediation with an outside mediator. Because I think that is could be a solution. Depends on all the circumstances. I mean, I did just reminded me of a workplace mediation that I was involved in, and we did it in 2 stages. And at the end, it was a possible alleged harassment case. The employee, they did resolve it. The employee had no idea about the impact of what she had said on the other employee, and was very, very upset that he was so upset. And so there was clearly an underlying misunderstanding about it wasn't a serious harassment case at all. Wasn't really a harassment case. It was interpreted as such, possibly. But I would think possibly getting an external mediator, even if it's for a 3-hour morning mediation, to make it a formal mediation. But I think it's quite hard, probably, if you're in HR mediating to employees, in case one of them thinks you might have a preference for the other, or there may be a lack of impartiality. I'm not saying there is in this case at all. It's all about perception. And you have someone who is entirely impartial outside the organization. Might be worth it and would save your time and stress.
Who writes the position statement? I assume it's a mediator after assimilating initial information, but I'd rather have factual answers than make up assumptions.
No, it's not the mediator who writes it, it's the individual who writes it, but then the mediator might suggest a toning down of some of the language if it is if it's in the sort of blame style. And so I would look at a position statement. Sometimes you don't get to look at a position statement, but I would suggest that it be as positive as possible. Ultimately, it's up to the individual, but I would not write a position statement. That would be from the individual, but I would comment on it. So if it was, I've had years of harassment and discrimination, I would then suggest that it was reframed to say, I feel as though I've been badly treated because I didn't get promotion or I didn't get training. So it's not the allegation, but it's stating the facts in a less inflammatory way.
Does a mediator need insurance for his or her own protection?
Yes, I think they do. It doesn't cost very much because it's not like litigating. You're not advising.
What proportion of mediation processes are successfully resolved without subsequent legal proceedings, and are medical disputes any different?
I don't know the answer to that. I know that in the employment judicial mediation, the success, it's quite difficult actually, because often the success rate may not be very high, it may be 60%, but then that doesn't count cases which settle, before the hearing. I don't know about medical disputes, I just don't know.
Can the mediation meeting between 2 parties take place over more than one meeting if an agreement or a solution is not reached?
Yes, it's a very flexible process. It may be you think that you have a discussion over a period, and sometimes that works better because it gives each party a bit of time to mull over and think about what they want. And I think that often a good solution is to to give parties time to think. So in a mediation, if a party says that's completely outrageous, I'm not going to take that, I would say, look, why don't you go and have 15 minutes and just think about what you want me to say? And I think that particularly if you're hoping that two employees will meet and discuss eventually the issues between them, it may take time, particularly if one at the beginning says, I'm not meeting them. I've had that in the mediation. You just need to, the mediator needs to assess what the individual is thinking and needing at the time, and how best to encourage, say, a meeting or whatever outcome is wanted.
My experience and understanding is that in order for mediation to have real chances of being successful, all parties should be treated as equal. It is my understanding that otherwise this process cannot be balanced and fair. However, in the NHS and healthcare, there are discriminations and a class system that does not appear to facilitate mediation. For example, employee A's experience, I've been bullied, is considered less important or wrong, and employee B's view of you weren't bullied is considered more important or right because they are in a senior or management role. How would you go around this significant obstacle?
Well, I think it's for the mediator to try and ensure there's an equal playing field. So the mediator, in my view, would try and make sure both parties were actually equal. And if one party had a completely different view, then the mediator could suggest that there were other ways of looking at it, and that it was important to consider the view of the other party if a solution was to be found, because there will always be views that in a judicial mediation, both parties are absolutely sure they're right. You're never going to change that. But what the focus is on finding a solution which is acceptable to both parties. So moving to solutions, which, I mean, sometimes I say it may be not exactly what you want, it probably isn't, but at least it's tolerable and it's much better than going to a tribunal. So I do think the mediator is there to make sure that neither party is disadvantaged by the power of one party. I mean, the weaker party, if you put it like that, there's generally a power imbalance. That's much easier to deal with than it is in the court, where you have a totally different role.
What is an exit strategy for a mediator if things are not progressing?
I don't know what you mean by exit strategy, ending the mediation. I'm a very great believer in staying the day. I would not want to be exiting from a mediation unless I was told, well, absolutely clearly by a party that they weren't going to continue. I would encourage them to continue to the end of the day. I have seen so many mediations where at about 12:30, the one or both parties say, we're never going to settle this, we're never going to settle. I said, look, I say at the beginning, please stay the day. And so often towards the end of the day, it does get settled. So I don't ever want to exit, even if I think it's going badly. I'm hoping, I often say I'm optimist, I am hoping that there will be resolution. I'm going to have to, I think, go after the next question, because I know that I've got something else on at 2:15.
No problem. NHS trust policy will not allow, oh, sorry, that's not a question. How can mediation aid an exit strategy plan for a party who feels they've been mistreated to such a degree that they can no longer work with the other party? Is that possible? And if possible, how can they aid that?
Yes, and that's often what happens, that one party feels they can't remain, and the only possible outcome they see, unless they're persuaded otherwise in the mediation by the other party, is to exit and maybe get compensation for an exit. Or thinking outside the box, is there anything that could be agreed which would be acceptable to both parties for one of them to be moving on? It all depends on the circumstances. It is quite often that one party will want to leave.
Thank you. So in the interest of you having to leave, we'll wrap it up now. Thank you, Camilla.
Sorry. Yes, okay. I'm very happy. Sorry, I'm very happy to answer other questions, if that helps. Sorry.
I can send you through a list if you would like.
Silent mode.
Or
I don't know
if anyone has any other questions, if you could email info@bmalaw.co.uk and someone can get back to you about those. Thank you, Camilla.
Okay, thank you very much.
Thank you. Bye.
Thank you. Bye.